Welcome everyone. My name is Cesar Rodriguez Garavito. I'm the director of the Climate Litigation Accelerator at the Center for Human Rights and World Justice at New York University School of Law. And as some of you who may have attended previous webinars that we organized, we put together a monthly event in which the community of practice that CLX curates with organizations from around the world comes together first in a public event, which is going to last for an hour today, and then for a shorter strategic meeting to discuss exciting, useful, directly impactful developments in science, in the law, in communications that litigants and advocates and researchers can learn from and hopefully directly apply in their own context in order to speed up and scale up climate action, which is the mission of CLX. CLX was established to be a catalyst for the climate litigation field. And this is one of the modalities of engagement that we undertake. We also work with partners around the world, actually pursuing litigation or incubating ideas for litigation that then go on to be implemented in various jurisdictions around the world. So we're particularly excited about this webinar because it really is about a fantastically interesting and I would say even unexpected type of case, because it takes place in a jurisdiction in Australia that is not particularly well known for being very conducive or welcoming for climate litigation, based on the types of legal grounds that I don't want to give too much detail because we have fantastic panelists today, and we'll give them the floor to explain what the case was about and what the novelties of the case are about. But the fact that it is it has taken place in Australia is pretty remarkable. Australia being, of course, one of the major coal exporters in the world. And then another remarkable feature is that it joins a series of efforts to advocate for the rights of young people. And so this is very much a case in which young people and future generations are at the center of the legal arguments. And then finally, we've discussed here, in fact, last month, our webinar was about the Shell case. So this is part of a mini series of impactful, interesting litigation to try to put pressure on fossil fuel companies to align their commitments, their business models with what science and the goals of the Paris Agreement have envisaged. So for that, we'll have to discuss all the angles of this very interesting and timely case. We have three fantastic panelists, and the combination couldn't be better. I'll just introduce them very quickly, and then we'll go straight to the roundtable. As those of you who have come to previous webinars know, we don't have a series of presentations, but rather a first round of comments, and then with prompts that I offer, and then we'll engage hopefully in a more interactive dialogue among the participants. So with that, we have David Barnden. David is the principal lawyer at Equity Generation Lawyers. He represents the students from around Australia in the Sharma case, in the case we're discussing today. Prior to establishing the firm in 2019, David was a principal lawyer at Environmental Justice Australia, where he represented Guy and Kim Abrams in federal court proceedings against CBA, Australia's largest bank, for failing to disclose climate change risks to investors. There is experience in litigating complex class actions. At Morris Blackburn, he represented group members in proceedings against Guns, Farm, Treasury Wine States, and Cash Converters International. I'll introduce the other panelists as I give them the floor, but why don't we start with David? David, could you give us kind of an outline of the case and the key strategic choices that you, as the legal representative of the young plaintiffs, had to make along the way?
Thank you very much, Cesar. Thank you for having us. Just a little thing we do in Australia here. I'm speaking from Guyamagu land in Sydney, and I use he, him pronouns. In terms of the case, it's essentially establishing, or it was filed and sought to establish a duty of care owed by the Minister for the Environment. That's the federal Minister for the Environment in Australia, that when she went to approve a big fossil fuel project, in this case a coal mine expansion project, she had a duty of care not to harm children or cause them either injury or death when deciding to approve this mine. And that harm was specifically related to carbon emissions. And so we represent or represented 8 students who brought that case in September 2020. They were all aged between 13 and 17 at the time, and they were assisted by their litigation representative, an 86-year-old nun, who helped them bring the case, because when you're under 18 in Australia, you're under a technical legal incapacity and can't access the court without the help of an adult. So happy to expand more on the detail as we go ahead.
Just a quick follow-up question, by the way. I wanted to thank David and Varsha in particular, because, well, it's almost midnight in Australia. And so they're really going the extra mile, or many extra hours, definitely. And we're very grateful to you both for connecting at such a late hour. So David, just a quick follow-up question. In considering the legal grounds for the case, what were the key strategic choices? Did you consider any other legal avenue, or what was the thinking process behind the legal strategy?
It's a great question. We're always thinking of different legal avenues. This particular one was worked up over some time, and we do get instructions from the children and Sister Bridget, and one of the particular concerns by younger people in Australia is the ongoing expansion and development of the fossil fuel industry, and it's something of major concern here, because it's something that is coal is exported generally, and therefore not counted under the traditional Paris Agreement accounting arrangements, and so it's like it's seen as a really big problem. In terms of the cause of action itself, in Australia we don't have any overarching human rights framework, at least at a federal level. There are some human rights acts in a couple of states, and we also don't have a highly developed set of rights, or largely any rights at all, under our constitution. So it was an attempt to use the common law, which has a sort of internal development mechanism to respond to some of changing issues in society, and we sort of researched quite heavily the line of authorities that allows the common law to develop, and there's a number of features that that a court needs to be satisfied or can look at, and we looked at all of those, and we could certainly mount a case using that. So we're sort of using the tools that were available to us.
Thank you, David. We'll come back to the specific legal ground that you all used, and how that relates to other cases in which human rights tools and norms and institutions are available, because there's kind of an affinity between the two arguments, but of course you had to work with what you had in Australia. So moving on to Varsha for a moment, I wanted to give you a chance to comment on the role of young people in the case, but I will introduce you first. So Varsha Yahman is a paralegal at Equity Generation Lawyers. She joined in 2020 and works on the Sharma case. Varsha has been heavily involved in the climate movement as a previous organizer for the local and national team for School Strike for Climate, and the current North Wales schools coordinator for the Australian Youth Climate Coalition. Varsha is currently studying law and politics, and she works on the land of the Gadigal people of the Eora Nation. Varsha, could you comment on the case from the point of view of the young plaintiffs, what their involvement was, what the articulation between the legal strategy and the communication strategy and the activist social movement strategy was?
Yeah, sure. So just before I begin, I'm currently on the land of the Darug and Gurungai people. This always was and always will be Aboriginal land. But regarding the role of children, I guess just their view. So since November 2018, we've had hundreds and thousands of people march across Australia calling on for climate justice. And that movement has been led by young people, and it's quite incredible. And we've seen it happen all around the world. And what's been quite frustrating is we haven't really seen any action taken by our government. Instead, we've seen Australia be the largest exporter of coal and, have such a lack of a climate policy. And we've also seen the expansion of the coal and the gas industry. So this is really, really evident in our net zero to 2050 plan that was unveiled a couple days ago. It really isn't a plan. It doesn't really have the modeling. It's not backed up by any sort of short-term targets that are actually ambitious enough to reach net zero. And the target isn't even enshrined in law. So we've had our Prime Minister talking about, it's just about getting there. It's not about political commitments. And this can feel quite demotivating. It can feel quite anxiety provoking for young people, because it feels like there's no avenue and there's no voice or platform to really voice our fears on the calamities that climate change is bringing us now, but these calamities are going to be even more catastrophic in the future. So for us, this case is quite significant. And being part of the school strike for climate movement previously, we've always wanted to feel, I guess, more legitimate, and a bunch of young people shouting across on the streets doesn't always feel like that, and you're not portrayed like that in the media. So having this team of lawyers and some of the best barristers in the world come up to you and say, we're willing to take this to court and say that the government needs to be held to account and that they owe you a duty of care, is really empowering. And it feels like there's purpose and there's a reason behind what you're doing. And I think it allows you to kind of channel that fear and anxiety in a way that is a lot more productive and effective. So having that more, I guess, informal space of protest and strikes is amazing, but in combination with this formal avenue as well is really, really empowering.
Thank you, Varsha. I will definitely come back to the role of young people in this case and what the court said and in the initial ruling. But first, let's complete the first round with Nick, who for some reason I thought was in London, and other people in our audience are already going to or arriving in Glasgow in the UK. But I see that Nick is still in Australia, so I send my gratitude to you as well, because it also is almost midnight for you, Nick. So thanks for taking the time or taking some hours off for your sleep today. Hopefully you'll make up for it tomorrow morning. But Nick has a really complimentary and a very helpful perspective on this case, because he was involved in it, but he also plays a key role as Nick Kelly as the head of the energy portfolio for the Foundation for International Law for the Environment, FILE, and has served as the director of legal for both FILE and the Sunrise Project. And he worked closely with the Sharma team in bringing the case. Nick practiced as a lawyer for 13 years, first as a solicitor and then as a barrister, and he specialized in inquiries, planning, and environmental law. He worked as a judge's associate in the federal court and as the legal research officer at the High Court, as well as teaching public and constitutional law at the Australian National University and the University of Sydney. So, Nick, I know you're very familiar with all the details of the case, but to start us off, could you put this case in the context of your broader work on energy and energy transition? What's specific about this case? What you see as the usefulness of this case for the global efforts to try to align fossil fuel production with urgent climate action, climate mitigation?
Yeah, thanks, Cesar. And I would like to first acknowledge that I'm coming to you from the land of the Wurundjeri people of the Kulin Nation in Melbourne, and sovereignty was never ceded. I think one of the things that this case has done most importantly is sort of demonstrated what's possible. I think, breaking open torts as an opportunity, as a basis on which meaningful action can be taken to stop new coal developments is something that we hadn't really seen before, certainly in Australia. And I think also demonstrating the power of young people when they get together and have the opportunity to work, are given the opportunity to really, tell their story in the context of novel legal interventions. But in many ways, I think what's most significant about this case is the way in which it put evidence of the both the impacts of climate change and the contribution of the further mining of fossil fuels to those impacts before the court in a way which was uncontested by the government. So it allowed the court to really make some quite powerful findings about what will happen if we allow fossil fuel development to continue unchecked, and the impact that we will see as a result of that, and the impact that it will have on young people coming into the future. So I think that's one of the most impactful things that I see coming out of this case for the work that I do.
Thanks, Nick. And now we're moving on to a more interactive round of interventions, and by any means, please feel free to jump in, regardless of who I ask to answer any specific question. So I want to come back quickly to David and ask him to update us on the outcomes of the case and what the next steps in the litigation and also in the legal and mobilization strategy are. So let's start with that.
Yeah, so we were successful at the first instance, so after the evidence was presented to the court. And the single judge of the federal court, Justice Bromberg, decided in our favour that a duty of care did exist for the minister to take reasonable care to avoid causing personal harm, personal injury and death to the children by carbon emissions from the project. We did not succeed on the claim for an injunction. So there was a special type of injunction that we also sought from the court, and that dealt with an imminent breach of the duty of care. So the judge effectively did not want to order that in circumstances where the minister would only find out about the duty of care from the judgment. So he effectively said, look, I've heard the evidence. The minister's had the opportunity to listen to the evidence as well. This is my judgment. I find that a duty exists. And so now it's up to the minister to decide, because I don't have any evidence before me about whether or not she may approve the project, may not approve the project, or may, as a result of either of those, breach the duty. So we weren't successful on that injunction. We were successful on the existence of a duty. A week after that decision came out, which crystallised the duty, the minister announced that she would appeal the decision, and that appeal was filed shortly after in in August, and we recently had the appeal hearing, so 3 days before the federal court last week, from Monday, Tuesday and Wednesday, and now the court has reserved its decision, and hopefully we'll get that within the next couple of months. It is worth mentioning here that in the interim, before the appeal hearing, the minister did actually approve the project. So we're in a position where the court now, this is the appeal court, is dealing with whether or not a duty exists, and is not dealing with whether or not the minister has breached her duty by virtue of the decision she has made. So we'll wait to see what the full federal court says. So that's 3 judges of the federal court. And then the next and final appeal avenue is to the High Court before 7 judges. And that's where it stops in Australia. And in terms of, I guess, in terms of mobilisation, well, look, I think I'd probably let Varsha speak to that. But, us being the mere lawyers, but we're behind the children all the way and their movement, and we'll do whatever we can to hang on to the duty.
Can I just jump in there and say,
yeah,
I think
sure.
I was going to say one of the things that I think, just picking up on what David said about the way that the court decided not to provide, not to grant an injunction at this particular stage, I think was deliberately leaving the door open for the minister to lawfully make a decision that threaded the needle between not breaching the duty and approving the decision, which would be, for example, to approve the mine subject to conditions that prevented any of the emissions from eventuating. Now, whether or not that's actually possible in practice is a different question to whether or not it was open to the minister to do that, which it was. And I think that was one of the things that the judge was really kind of batting back to the executive, so to speak. Yeah.
But the outcome was that the extension was approved without any condition, right? So the minister didn't kind of take the opportunity, if she had chosen to try to find a middle way between unconditional approval and a rejection of the petition of the approval.
Yeah, which means I think the question remains: is she currently in breach of the duty?
Great question. Varsha, you wanted to comment on the mobilization strategy?
Yeah, so in, I guess, getting our 8 clients who are just incredible and have been part of the school strike for climate movement, it was so quick. It was one quick message to a group saying, this is happening, would you be interested? And immediately people are jumping on board. And I think that really shows the desperation almost that we have to really diversify all the avenues that we can to get climate justice, and how motivated people are when, it's not really about the age, it's not really about any of that. It's truly about coming together on this common purpose of achieving climate justice. And the more avenues and the more pathways that we have to do that, the closer we get to achieving it. And I think this case is really a testament to that, in showing that there's so many different ways that people can come together, and just like the worldwide support on it has been incredible. And even in Australia, seeing other cases pop up now that are almost similar in a way, but also just bringing different climate strikers into the case. So seeing how young people are kind of, I guess, venturing into the legal avenue has been quite incredible.
Just a follow-up question on that important point, Varsha. One of the criticisms that us litigants get sometimes is that by working with social movements, including youth movements, the law tends to demobilize those collectives, and the struggles become too technical and framed in the language of the law. The evidence in many cases is the opposite, that there is kind of a synergy between legal and political strategies. But I wanted to give you a chance to comment on what the impact of this legal involvement has been on the movement that you were part of.
Yeah, so as I was saying before, I think by having this legal avenue come to you, it's more empowering. And I think when we're listening to young people, there's a tendency to kind of discard their opinions or say that they don't really know what they're doing. But by having a law firm take on 8 school strikers as their clients and saying, no, we're bringing a case to court and we're saying that the minister has a duty of care to them, really says that what they've been fighting for, what they've been chatting for on the streets, it does have a purpose, and that they're not just these outrageous children who want to skip school and that's their only reason for striking. So if anything, rather than demobilizing it, I think it's strengthened it. And I think it's also allowed people from different professions, from different angles, to see the severities of climate change. And by having it written down in a judgment saying, and having our evidence accepted, and saying that, you know, the harms of climate change are increasing and young people are going to be affected and it's going to get worse. Like, we're already facing these impacts. I think it really shows people that it's not just young people who care, but it's also, it's not an age divide. It's really everyone, and it doesn't matter regarding your status or your occupation. It's just a basic human rights issue at the end of the day.
Thanks, Marsha. And putting this case, and by the way, as those of you who have come to previous webinars will know, we'll take questions starting now from the audience. So please feel free to drop your questions in the chat box, and I'll be happy to share them with the roundtable participants. But going back to the importance of this case for ongoing efforts and ongoing thinking of on legal strategies against fossil fuel companies and governments that unconditionally sponsor extension of mines or new oil and gas and coal developments. I wanted to ask Nick to comment on the criticism that's sometimes made that the climate crisis is not going to be solved one project at a time. That if the strategy is to go after, you know, every coal mine authorization, every new oil deposit exploration, well, it'll take us too long, and the strategy won't get us to stay under 1.5 or 2 degrees of global warming. How would you see the place of project-based litigation in the broader struggle for climate litigation and climate action?
It's a great question. I mean, I think it's those cases are really important. They're the front line of the fight, and so they have to continue. I think this case demonstrates that even though it's about one project, it creates space for systemic change. So, for example, one of the most meaningful findings I think that came out of this particular case was that the protection of human life was a mandatory consideration under this statutory scheme that was deserving of elevated weight. Now, if that finding stands, then that will completely transform the way that assessment of all projects in Australia which are subject to this environmental regulatory regime are assessed. So while I agree that, you know, if we're looking at it on a project by project basis, we don't have the time to just do, you know, rely on single project cases. I think each of those has the potential to create really important systemic change. And also, I think it's important not to discount the way in which a single case can become emblematic for both the broader community and tell a story, a really important story, which goes to what Varsha was saying. And just by way of example, around the corner from where I live, someone has spray painted recently duty of care on the sidewalk. Now, I've no doubt that that's related to this case, and when in the history of the world have people been graffitiing about torts law? So I think that just demonstrates that, you know, that a single case has got a lot of power if the story is right. If the legal principles are as they are in this case, then they have the potential to also create systemic change. And that's the way that we need to be looking at them, I think.
Thanks, Nick. It is really a remarkable achievement of the case to make duty of care interesting to graffiti artists. Definitely, I've never seen any legal concepts painted on any wall. Nick, along those lines, you in your practice and with your colleagues are looking at various cases, different strategies to continue to put pressure, not just on governments, but also on corporations to do more against climate change, or at least stop doing as much harm on climate system. And I wanted to ask you to please comment on where you see this particular case fitting into broader strategies for climate action, either because it's progress in terms of using private law, or because you've yourself learned about the importance of, or the usefulness of opposing a specific project, or any lessons that you could extract for your own practice and hopefully for the practice of other people here in the event that you have extracted from this particular engagement in this case.
I do really think the evidence aspect of it is critical. Like, what it shows us is that you get the evidence in front of a court. It's very hard, in particular for a government, but I suspect at this stage, any respondent to challenge that evidence, which means that you're starting from a pretty good standpoint, in that if the evidence is uncontested, that there are going to be catastrophic impacts of climate change, and that the contribution of increasing amounts of carbon into the atmosphere is going to make that happen, and make it happen in a way that's going to get worse and worse, then that means that a lot of the work has already been done before you start to get to the legal arguments. So I think that's one of the main lessons of it. Another, in the context of public interest litigation, is around not just thinking of the case as a case on its own, but thinking about the case as part of a broader campaign and as part of a broader communication strategy, such that you make sure that when your overarching goal is a strategic goal, that shouldn't necessarily be tied to whether you win or lose the case. And if you are successful in creating a campaign and a comm strategy around a case, then that means that you're not necessarily banking on whether or not you win or lose the case, because the broader political circumstances that you've created and that exist around that case mean that it becomes untenable for whoever it is that is the subject of the litigation not to act in the way that you want them to. And I think this case is a really good example of that. In Australia, as an Australian lawyer and also as an Australian public lawyer, there are a lot of things about this case that I think are really interesting and exciting. But that may be getting a little bit too into the weeds of Australian administrative law, I suspect.
Yeah. Well,
yeah.
Clearly the graffiti artists are interested. So want to offer a couple other lines there for the next work of art. David, along similar lines, what have been the main takeaways for you as a lawyer, as a legal practitioner, as you think about other cases, other strategies?
There's so many takeaways. It's hard to condense. Firstly, working with younger people has just been fantastic. There's an element in the evidence and the judicial reasoning that younger people are obviously going to face the worst impacts of climate change and are vulnerable to it. So there's certainly a strong desire from us to keep helping younger people protect their future. From a legal perspective, and I think a risk perspective, it should embolden other lawyers, particularly in Australia, to go ahead with claims that they may otherwise think, or barristers or the general population may otherwise think that the judiciary is not ready for. Because as Nick said, and Vash alluded to, that if you put strong evidence before the court, they will look at it, and they will look at it seriously. And if it can interleave within a good cause of action like we had here, then I think things are looking up. So ambition is certainly a good lesson here.
Actually, that's a great segue into one of the questions from the participants here in the chat box. People are interested in hearing a bit more about the evidence that you presented. Could you elaborate on that, both on the content and how you obtain it? Where did you collaborate with scientists? That's always kind of a key piece of the type of litigation that we're discussing here, because the science is complex, the evidence is quite complex. So how do you work on that particular piece of the legal strategy?
Yeah, look, the evidence was extraordinarily important. So we had a specialist evidence barrister come on to deal with that. Essentially, there were the three categories of witnesses. There were the students themselves who put on affidavits around their experiences and concerns on climate change. There was, secondly, a group of firefighters who put on lay witness evidence about their experience fighting fires and how that's getting worse in Australia, to sort of paint the picture that what's extreme now will be commonplace in the future. And third, and most importantly, as far as the judgment is concerned, were the expert evidence. Sorry, the expert witnesses. We had 4 of those. There was a climate scientist, a public health expert, an actuary, and someone who crunched some numbers on economic analysis. The key expert was the scientific expert, and he put on evidence that made us be able to make the emissions from a single mine project tangibly material to future harm, so which would manifest as a result of this global problem that is climate change. And so we had this evidence from Professor Will Steffen, who works at one of the best universities in Australia and also contributes to the IPCC. And his opinion was that 100 million tonnes of carbon emissions in the atmosphere would potentially trip the world over into trigger points and non-linear impacts. And so as the world goes from 2 degrees average global warming and above, those risks increase. So it's ever more likely that these tipping points will get triggered. So one mine, and you know, a reasonably big one, can make a difference. And his evidence which was quite startling for some of the team of barristers who worked with us, was that it's quite unlikely that the world will be able to stabilize at 3 degrees, because the likelihood of tipping points, you know, this is melting the Greenland ice sheet, sort of bushfires that sort of self-perpetuate, reversing, you know, critical ocean currents, was so strong that it would cause these feedback loops, releasing more and more carbon, that we'd be headed to a hot house Earth scenario at around 4 degrees. So that was quite striking. In terms of the logistics, we've reached out to a number of experts. We vetted experts. We got the best expert evidence we could get, and you know, we're very grateful, because some of these people gave up a lot of their time to help us and to help the students. So it was really lovely.
Thank you, David. I wanted to ask Varsha, but also David and Nick, feel free to jump in as well, about potential backlash, which is one of the questions that one of the audience participants is asking about, because in many contexts, not just in Australia, but CLX is working quite actively in Brazil and other places in which issues of economic development, of the advancement of economic development through specific industries, from coal to beef exports, gets entangled with the nationalist discourses and the fact that that's what kind of the national identity is about. So, and coal being quite visible in the public sphere in Australia, having been the reason why prime ministers and the regulation of coal, the regulation of fossil fuels have had to leave office. One can anticipate that there's backlash in the public, in the media, in the public sphere against this type of arguments being advanced by cases like Sharma. So I wanted to ask Varsha how the movement has dealt with the opposite views on going against the coal industry, and what's been the response of young activists and in the aftermath of the ruling in the case.
Yeah, so I think as long as any sort of climate movement campaigns have been going on, there's always been backlash. And I think at the start there was an increasing amount of backlash, or rather there was less media coverage in some angles and more media coverage depicting the climate movement and young people as just being irrational and not really caring about the economics and not really understanding profits and all of those things. And I'm not going to say that a 13-year-old is able to understand the technicalities of the economy. I mean, I don't think I do either. But what's really important to understand is that the whole idea of the economy suddenly falling apart if we have a proper plan to actually reach net zero emissions to achieve climate justice, it's entirely a myth that the media and I guess a lot of our politicians in Australia have created, that these industries are just going to fall apart and people are not going to have a job. The entire idea of the climate movement is to make sure that people are financially stable, that we aren't leaving anyone behind, as cliche as that sounds, by having a just transition. So by allowing these people to work in the renewable energy industry. So why that's really important is because in the longer term, the coal and gas mining industry is not going to be sustainable anyway, not just for the environment, but also financially. We're already seeing the prices go up, and we're already seeing that it's really not allowing job growth, and it's not allowing for expansion and innovation, but the renewable energy industry is allowing that. And especially in Australia, we do have the resources to be a renewable superpower. And the fact that we're not exploiting that and making use of that to its full potential is what is quite frustrating. So I think young people especially have to always justify themselves and prove that they understand what they're talking about. And I think this case really allows for that to not be as big of an issue, because it's genuinely holding the government to a standard and saying that you're falling short of this standard by allowing the approval of these coal mines, by continuing to allow the increase of emissions, because it actually isn't sustainable both economically and also environmentally.
Thanks, Varsha. One thing that's also appealing about this case is that it's a very creative deployment of private law, or a combination of private law arguments and kind of public law purposes. And as David was saying towards the beginning of today's conversation, the lawyers worked with what they had at hand. And most of the cases that we've discussed here in the CLX webinar space have been about arguments being made on public law grounds of human rights, constitutional law, but there's an increasing amount of cases or either already filed or in the making that are actively mobilizing tools of private law, from securities law to tort, to other forms of corporate law that are putting pressure more directly on corporate actors. And in fact, in the Shell case, we discussed a combination of private law and again human rights law informing the application of private law. So I want to give David and Nick a chance to comment on that, on what you see as the potential of leveraging private law tools and ideas, be it torts or other branches of the law, to advance climate action and put real pressure on governments and corporations.
Yeah, look, I mean, it's coming back to that idea of like the difference between project level litigation and systemic litigation. I think this is a really interesting aspect to that, in that as you start to see laws around finance, the way in which fossil fuel is financed being challenged, the ways around individual corporations' behaviour being challenged as attribution science gets more specific, and we find it easier to prove that a particular contribution and to the amount of fossil fuel in the atmosphere from a particular corporation can be attributed to very specific impacts. I think there's a lot of scope. Yeah, I think it's really interesting. I do think this case, though, is a really interesting and quite unique case about an interplay between public and private law. And one of what's at the heart in many ways of the government's complaint about the decision is that the judge didn't quite do that dance as well as he should have, that he, the argument is in essence that the recognition of the duty is incoherent with the statutory power to approve the mine. And so that's entirely about the way in which these private common law duties can exist alongside these public law powers. And that's the bit that I think is, from a super nerdy legal perspective, probably the most interesting kind of legal thread in the case, and what we'll see coming out of the appeal.
Mm-hmm. Thanks, Nick. David, should I comment on that one?
Yeah, look, I certainly think that private law actions are going to be more and more prevalent. I mean, when I think about what the law generally protects, it protects people's health generally, and it also protects investors. It doesn't necessarily do a good job of protecting the environment per se. And often in public law, at least in Australia, you don't get an opportunity to review sort of the merits or like the impacts of a project. It's more about the process, and that may not sort of ultimately have the desired outcome in potentially stopping a particular decision. So I think, as you suggest, Cesar, that we will see more of it. We are also representing investors in Australia's biggest bank, $180 billion bank, CBA, and they're seeking documents, internal documents on whether or not the bank had sufficient internal systems to comply with its net zero policy, which ruled out financial support for new coal, oil and gas projects unless they were aligned with the Paris Agreement, and it transpired that 7 of those projects were financed. And we're also sort of looking at superannuation cases. We've run of those before for a 23-year-old superannuation fund member. So these types of actions are gathering steam, and I think they will be powerful, especially where governments are slow to act, and so getting private sector and investors to act more appropriately will be very powerful.
Thanks, David. We have about 8 minutes left, and the audience got enthusiastic about many of the points in the very last segment of the event. So I'm gonna try to cluster to put together these various questions into 3 clusters, so that I have to give you each a chance to offer kind of 2-minute comments in closing. And a few questions relate to the future of the case and the relationship between, again, the legal strategy and the political strategy. So, Varsha, because of course the decision now is on appeal. No one knows how the court is going to rule. What might be kind of the alternative scenarios for the movement? Say if the ruling is reversed, how would that feed into the mobilization strategies going forward? The case has been empowering, and yet no lawyer, not even the great lawyers that you have at the moment, cannot guarantee an outcome in the next round of the case. And how do you see this playing out going forward in both scenarios of winning or losing on appeal?
Yeah, so this might be a bit of a bleak answer, but I think in terms of losing, in the climate movement, I find that we're hit by a lot more losses than wins. Generally, just it's a very recurring trend of loss, 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 and then a small win here. And yeah, I think we're quite used to it. And I feel like when we go into something, when we go into any sort of campaign, or when we go into another way to go and fight for climate justice, it's never with the intention of we are going to win, but I think with the intention of how much awareness can we spread through it and how many people can we mobilize along the way. And I think this case definitely has. It's received so much of attention, and attention from people who we wouldn't normally receive that sort of attention from, I guess, because it's obviously been in publications that a climate change case or climate change campaigns would never before. So yeah, I think regardless of whether we win or lose, it has had such a positive impact on the movement, just in general terms of making people aware that climate change is being taken more seriously. And I think even if we lost at first instance, the fact that it went to court and the court found that it was a serious question to be tried, that whether a duty of care existed or not, in itself is such an important step. And now having a judgment that accepts the evidence, that says so much, does really mean a lot to people who have been part of the climate movement for a long time.
Thank you, Barsha. Now, on other cases, Nick, I don't know if Nick or David could comment on how the Sharma case fits into what seems to be kind of a series of new cases being filed before various courts in Australia. How do you see this recent wave of cases and where this might go in terms of putting pressure both on corporate actors and the government to do more about climate change?
I mean, there was a case filed this week which used similar arguments on a duty of care, and that I mean it's fascinating that the duty of care in our particular case was founded or existed in the context of the environmental approval legislation, whereas this the new case filed this week on behalf of Torres Strait Islanders uses the Native Title Act and the Torres Strait Island Treaty to found the duty of care. So that's really exciting. We do see a fair bit of impact from the Sharma case on corporate actors. We see, it wasn't long after the decision that BHP said it was not going to go ahead with a particular mine expansion. Whether or not that had anything to do with the case, I don't know. But the case also does provide activists some opportunities with respect to petitioning both companies and their financiers not to finance projects. And it's a very compelling argument when you can go to a bank who's considering tipping in to actually raise funds for this precise project. And you can say, look, a judge of the federal court has said this precise project will increase the risk of personal injury and death to children. And it's got to be pretty tough for a bank to be involved in something like that.
Thanks, David. And I think that addresses another question about the possibility of the duty of care applying to private sector actors. And finally, one question that's kind of in the subtext of some of these, for example, Pubin asks about the potential impact of this case in other jurisdictions. One thing that one needs to remember, which David just brought up in mentioning the BHP Billington, is that many of the corporate actors in the coal industry in Australia are also major transnational actors, right, operating around the globe. So one question maybe in closing for Nick is what global repercussions in terms of the operation of these transnational actors might you anticipate as cases like Sharma and the more recently filed case put pressure either in the public media or before the tribunals on coal producers and fossil fuel producers that have transnational operations?
Yeah, look, I think in the context of the cases that we've seen recently, particularly this one and Shell, I think you can say that fossil fuel producers are going to be very clearly understanding that there is an increasing amount of risk wherever they turn. So whether that's at a permitting stage when they're trying to get a project through on standard environmental planning principles, these issues are going to be live. Whether it's on financing that project, these issues are going to be live. Whether it's on ensuring that project, these issues are going to be live. And then if they manage to get through all of the hurdles and actually go through with the project, then there's a real question now about a spectre of liability for the impacts that project may have on the health of humanity and individual groups within humanity. So I suspect you can bet it's having a really big impact in the boardrooms of those corporations around the world. And it will continue to do so.
That's a great note to end with, Nick. I wanted to thank again Varsha, David, and Nick for a very engaging and also very useful, directly useful conversation. I think we've managed to cover not just the case, but the issue and the industry from many angles. And we could go on for a long time, but hopefully we'll save the next conversation for when the final, hopefully positive decision comes out. But in the meantime, for those of you who are part of the are registered as members of the CLX community of practice, we'll move to a separate link for the strategic conversation with David, Nick, Varsha. They've agreed to be with us for 30 more minutes. It's already tomorrow for them. So thank you again for the extra effort. And for those of you who have not registered yet as members of CLX's community to practice, please feel free to email Jackie Galland in the link that was provided along with the invitation for this webinar. And we'll be announcing the next month's webinar very soon. Thanks everyone again, and see you on the other side for those of you who are part of the community to practice. Bye-bye.